All right, good afternoon. Hello, everyone. My name is Jocelyn Rosnick, and I'm Policy Director at the ACLU of Ohio. And I want to thank each of you for taking some time out of your beautiful Friday afternoon to spend it with us for today's program, Ohio's Cash Bail System and the Path to Reform. I'd like to first start with a little bit of housekeeping. As an FYI, this event is being recorded and will be posted to YouTube at a later date. Additionally, we do have live captioning, and we will be dropping the stream text link in the chat if you would like to follow along with that live captioning. Additionally, for any attorneys here with us today, this program has been approved for 1.25 CLE hours through the Supreme Court of Ohio. If you are seeking that CLE credit, you must stay for the entire program. At the end of the discussion, we will have a CLE credit code, and we'll provide a link to an online form where you would then insert that code in order to get your CLE credit. Additionally, we will have Q&A. We will hold that at the end of the program, but we do have a number of speakers with us. So if you think of a really good question, you can jot it down and hold it to the end, or you can just drop it in the chat whenever you think of that question. Myself and two other ACLU colleagues will be monitoring the chat the entire program, and we'll pull out the questions to bring them up around 1 o'clock when we should reach Q&A. So with that, I'd like to dive in. For years, we know that bail reform has been at the center of public conversation. And this is because on any given day in Ohio, more than 12,000 individuals who are unsentenced are languishing in an Ohio jail. That makes up more than 2/3 of the total jail bed usage in Ohio. To discuss current bail practices, the pitfalls, and possible ways forward, we're honored to have Chief Justice Maureen O'Connor of the Supreme Court of Ohio, Claire Chevrier, Policy Counsel at the ACLU of Ohio, Daniel Dew, previously of the Buckeye Institute, currently at the Pacific Legal Foundation, here in his capacity as a bail expert, Dr. Zaria Davis, Senior Associate at the Pretrial Justice Institute, and Anthony Body, Bail Disruptor at the Bail Project. So let's dive in. I'd like to kick things off with Chief Justice O'Connor. I want to thank you again for sharing your Friday lunch hour with us and for your interest in advocacy on critical issues like fines, fees, and bail. I'm wondering if you can provide some opening remarks, letting our audience know why you think the time for bail reform in Ohio is now.
Great. Well, thank you very much, Jocelyn, for the invitation to be here. And just so you know, you're not interrupting my lunch. I never take lunch. So I was glad to, fill in this time slot. Bail reform, true bail reform it is something that I'm vitally interested in and have been for quite some time. And the same.
Oh, Chief Justice O'Connor, we lost your audio.
All right. Can you hear me now?
Yes.
Okay. Could you hear me to begin with, or should I start over?
We heard the beginning.
Okay. All right. Well, bail reform, true bail reform, has been something that I think we have an interest in common and have for quite some time. The good news is that reform has been unfolding in Ohio. In July of 2019, the task force to examine the Ohio bail system, which I commissioned, issued its final report with 9 what I consider very solid recommendations for reform. We look back on 2020 as the year of the pandemic, but when it comes to bail reform in Ohio, it was a year when we were making some progress with regards to bail. Great progress was made 1 year after the task force report was released. For the first time, we have achieved the kind of momentum that can sustain reform efforts in this and other areas that the court is concerned with. It is and has been a long path to reform, but I think that we're on that path and we're moving in the right direction. In 2020, we changed the rules governing bail, bond, and pretrial release in criminal cases. That was a monumental achievement given the inaction that prevailed in our state for so many decades. Courts in Ohio today are now required to use the least restrictive bond conditions and the least amount of monetary bail to ensure the appearance of a defendant. In fact, monetary bail is not your first go-to. Recognizance, personal recognizance should be the first direction that the court would address when it comes to release. Today, bond schedules are to be used only for securing release before an initial appearance, and they are not to be considered by the trial court during the bond hearing. Now, our task force also called for leveraging technology solutions that support pretrial reform. This is happening through Ohio technology initiatives, and these steps can be as simple and basic as texting individuals for court date notification. It seems now, because we're so familiar with texting and we communicate so directly, so often, it seems like a kind of a no-brainer. But that is something new to the court system, the probation department, as of it's recent, but it's proven to be highly effective and a tool that I think the judiciary and the probation department and those that are responsible for getting people to court are relying on more and more. Our tech grant program is open right now for our 7th consecutive year. And these are the type of projects that we fund. The task force also called for a comprehensive statewide uniform data collection system to support fair and effective pretrial process. This is kind of the topic, the initiative, the interest that I will be pursuing, have been pursuing and will pursue for the next 2 years. Many of you know that I have 2 years left in my term, and then I will be ineligible to run again. So this is an initiative that we're working on and making great progress. Actually, we're going further than pretrial in all aspects of sentencing, and we're building a system to collect, compile, and analyze criminal justice information across the spectrum in our state. The data collection system will begin with sentencing data, but eventually contain data on arrests, on charging decisions, on pretrial decisions, as well as trial and sentencing data. Having a comprehensive data system will build a true foundation in Ohio for racial justice and fairness to all. These are first steps, but I think they're big steps. In fact, they're huge steps. We broke through extremely tough barriers last year. When it comes to bail reform, I'm happy to say that we have a spirit of working together across ideological and political spectrums. We need to do more of that. But here are some encouraging facts. In 2018, the National Center for State Courts released a survey. It said that the American public was primed to consider bail reform. And I think the interest in the public has only grown since this survey in 2018. When asked in that survey, the current system of cash bail produces a two-tier justice system with wealthy defendants able to walk free while low-income defendants are jailed. More than 50% of the people who responded agreed with that statement. This was 2 years before the consciousness raising of justice issues followed by the killing of George Floyd. We know that the events of last summer focused our country even more on the inequities in our criminal justice system, and George Floyd was only the beginning, unfortunately. Having said that, just like any movement that breaks with the past, our push remains an uphill one. The bail system has developed its own economy within the American economy, and that is no surprise to anybody that is listening to this Zoom call. The bail trade has staying power because it's a for-profit enterprise. It is supported by social assumptions and favorable laws, and the system has long-standing financial backing. The injustices of the bail trade will be discussed here today by the panel, and I would like to make 3 points to give strength to those seeking reform. First, telling the true stories of how bail unfairly affects Ohioans has been critical. Human examples go a long way towards achieving a high level of public knowledge and public support. Those stories were told at our task force meeting. Long before that, the Marshall Project, the ACLU, and others were telling these stories too. The news media has joined in, and recent publicity has been favorable towards reform. Secondly, the alleged need for high levels or any level of bail for nonviolent offenders is being revealed as a fallacy. The technology I mentioned is working and can be further implemented. Text alerts and other ordinary means of communication get people to court on time. And now, due to the pandemic, we're witnessing Zoom hearings that work well. That is, if you don't accidentally use your cat filter, I should say. The third point is the major criminal justice database project underway in Ohio that I just described. By examining our justice systems comprehensively, reform efforts become a bigger picture, a mural for all of us to see. We know that real life stories have played a key role in bail reform. Adding hard data to these stories on an ongoing basis creates powerful evidence on the side of justice. So I'm very glad to be here. Thank you again for having me. I look forward to this afternoon's discussion and hearing from the panelists, and then to possibly answer questions if there's enough time at the end of this program. Jocelyn, I'll turn it back to you.
Thank you so much, Chief Justice O'Connor. I really appreciate your remarks, and the ACLU is excited about the sentencing database project. And I really do love thinking about how we can leverage technology. And I think court texting reminders are such a good example. I get text reminders almost every day reminding me about, my dentist appointment, a doctor's appointment, or anything in between. And we do know that those simple solutions can help highly increase appearance rates back to court. So I think that is a great note. So we're going to turn to Dr. Zaria to walk us through the history of pretrial, address some of the relevant case law and constitutional provisions, and I am hopefully going to share my screen and walk through the slide deck that Dr. Zaria created for us.
Yeah. So we'll go ahead and get started. So as our Supreme Court Justice just explained, and we always just try to start, when we talk about the bail system, oftentimes people can get confused with the term bail versus bond. So we always just try to start with just going over like what that actually looks like. So bail is a system that is set up, it's a system of release. It's a process, not a condition. It is not money. So you'll hear terms like bailable, which is releasable, as well as not bailable, which is detainable. So we just like to start there just so people understand when we're talking about this particular topic, just the proper terminology. So we'll go to the next slide. And today what I'm just gonna do is kind of walk through a little bit of the history around this system, and actually starting from England, since a lot of the things that we have here in the United States obviously was birthed there. So when we start, we look at 1850, and in this society, crime was really viewed as a private matter. If one person was to steal property from someone else or harm someone, it was likely to result in a blood feud between the two parties and their families, which could potentially result in a fight to the death or sometimes even war. But in order to really provide a more civilized alternative to this, a new system was developed and based on the use of what they call a bot. And so this was a payment due to settle a grievance. It's essentially compensation to the victim for a loss caused by a crime. And while the two parties sort out like what happened, who's responsible, the accused person must find a personal surety who will pledge to pay that bot if the accused person was to avoid pain or was to flee. So so this is kind of how we get started with this system, and we'll keep going. So we can go to the next slide. We kind of move ahead in time to the Battle of Hastings, where this happened when William of Normandy defeated Harold, who was the sitting king of England. And once William takes over England, the throne, he establishes new laws. And so part of that is that crime is no longer seen as a private matter, but actually an offense against the crown. So a criminal justice system is put in place with the appointment of judges to hear cases, sheriffs to operate jails, with judges writing a circuit. There was a lengthy amount of delay, obviously, between arrest and trial with that set up, raising concerns about jailing accused people for extended periods of time before they could actually have a trial. And so to address this, the system of bots evolved into what we now know of as unsecured bonds. Next slide. So in the 1680s, the jails were extremely crowded because the money amounts assigned to unsecured bonds were being set at a much higher level than they had been in the past. And so as a result, personal sureties were loath to sign them. And as a result of that, many more people who were charged with the crime were sitting in jail. Next slide. So what ended up happening is, again, in the 1680s, because of its crowdedness and the money amounts being assigned to the unsecured bonds being so high, personal sureties, again, had people sitting in the jail. So in 1689, Parliament learned that this new system, which that had been in place for centuries, was basically being abused by the judges, setting very high unsecured bond amounts. And so Parliament passed what is known to be called the English Bill of Rights. And one of those provisions for the Bill of Rights is the language saying that excessive bail ought not be required when setting the money amount for an unsecured bond. So as we talk about England, we also have to think about that, obviously this land was occupied prior to English settlers. And here in North America, the indigenous population actually had a different set of things that they kind of did to address injustices as we describe it. So this slide includes a list of some of the general principles that the indigenous system encompassed. And while each tribe and community had their own unique way of practices, these are just some samples of the ways that they were being addressed. And just kind of going over some of them, a lot of them were connected to what we would consider now as like more restorative justice practices. And I know a lot of people are kind of looking at that as a motto. So you can go to the next slide. Looking at the 13 colonies. So the original 13 colonies from England obviously were governed by English law, which includes the bail laws. And even after the win of our independence, our laws continue to be based off of English law. So when we ratified the 8th Amendment to the new US Constitution in 1789, exactly 100 years after the English Bill of Rights was enacted, it's not surprising, of course, that we adopted the excessive bail clause as a part of that. So the bail practice remained the same in the United States and primarily was based on personal sureties. Next slide. So as we're thinking about just kind of the movement within the development of this country, in 1619, enslaved Africans were starting to being brought over to this land and working obviously for free and contributing to what we now know is the United States of America. Next slide. And so when we look at the 13th Amendment, and this has been, I know, a conversation even here in Ohio, there is a clause in there that basically, although it abolishes slavery, it says, except as punishment for crime whereof the party shall be duly convicted. And so that clause within the 13th Amendment has really opened up a lot of doors into what we now consider mass incarceration here in this particular country. Next slide. So as we start to think about the abolishment of slavery in this country, what happened is our criminal justice system really started to evolve. And instead of people being enslaved, people were criminalized. And that came in the form of a variety of different ways, but one of them was convict leasing. And convict leasing was a system in which Southern states leased prisoners to private railways, miners, large plantations, while states profited. Prisoners earned no pay and faced inhumane conditions, dangerous and often deadly work conditions until the 1930s. Again, this was primarily in Southern states where there were private companies that really got enormous wealth from the labor of mostly Black prisoners, again, who earned very little during this time. And again, this is generations after slavery was formally abolished. Next slide. Also, as we evolve in time, here just in Ohio alone, in 1804, we had what they call Black laws, which were enacted. And the Congress of the Buckeye State became the first legislative body in the country to enact Black laws intended to restrict rights for free Blacks. And so there were two groups that supported this particular measure, just based off of the proximity. But all Black residents had to register their names and children's names by June 1st of 1805, and there was a registration fee that was attached to that, and it became a punishable offense to employ a Black person who could not present a certificate of freedom. And so anyone that was harboring or helping fugitive slaves were fined, and basically this law was going on actually here in our state until 1849. So, you know, we have our own history here, right here in Ohio, as it relates to some of the practices for criminalizing people just solely based on race. And then in 1865, in some of the southern states, Mississippi, South Carolina, they did enact what they call Black codes, which require Black people to, again, have written evidence for employment. And basically, they were forced to forfeit their wages if they could not present proof of this. And so after the passing of the Civil Rights Act, Republicans in Congress effectively took control of Reconstruction. The Reconstruction Act of 1867 required Southern states to ratify the 14th Amendment, which granted equal protection of the Constitution to former slaves and enact universal male suffrage before they could rejoin the Union. The 15th Amendment, adopted in 1870, guaranteed that citizens had the right to vote, would not be denied on account of race, color, or previous conditions of servitude. And during this period of the radical Reconstruction, Blacks won elections in the Southern state governments, as well as even Congress. So we can go to the next slide. And as we go to 1898, the McDonough brothers this is kind of like the birth of the bail bonding industry. They were brothers who happened to be in San Francisco and were seated with some attorneys who frequented the saloon, and the brothers were making an arrangement with the lawyers. And basically the lawyers were concerned about their clients sitting in jail because they couldn't afford to get out on their secure bond. And so these particular brothers began to underwrite the secure bonds for these attorneys' clients for a fee. Next slide. As we evolve into the Jim Crow era, public parks were forbidden for African Americans to enter. Theaters, restaurants were segregated. Segregated waiting rooms in buses, trains, stations were required, as well as water fountains, restrooms, entering buildings, elevators, cemeteries, amusement parks. Laws basically forbade African Americans from living in certain neighborhoods. Segregation was enforced across the board for a lot of these places, as well as marriage and cohabitation between whites and Blacks were strictly forbidden in southern states. And so again, a lot of this is kind of going back to the criminalization piece of things. And then we go forward to the 1970s, where we talk about the war on drugs. And this was the first anti-opium law in the 1870s, which was directed by Chinese immigrants. It was directed at Chinese immigrants. And so in 1968, in the Nixon White House, they were basically identified two enemies, the anti-war left and Black people. And so one of Nixon's staffers actually stated that we knew we couldn't make it illegal to either be against the war or Blacks. So by getting the public to associate the hippies with marijuana and Blacks with heroin, and then criminalizing both heavily, we could disrupt these communities. We could arrest their leaders, raid their homes, break up their meetings, and vilify them night after night on the evening news. And so this was a huge shift in our country when we talk about the increase of people being incarcerated, people being arrested for these types of things. So the use of drugs began being criminalized, as well as some other things. And so this goes on until other laws were enacted, obviously, after this in the 80s. This behavior continues on into the 90s, which then kind of leads us to where we are now, which is 2021. And so many of those who have no access to money to pay secure financial bonds sit in jail until their cases are over, while those who do have access to money, regardless of how dangerous they may be, are able to buy their way out. And so little to no data has been collected on any official level. And I think that is across the board. In the work that I do, I talk with people in many states, and there's just very little information that's being gathered on the pretrial end of things. So given the lack of objective ways of measuring performance of the system, many officials assume that everything is working well, and they just kind of say, well, I don't see a problem with this, so there's no need to fix something that isn't broken. So it's really time for us to think about like our history and how this is impacting families, and just the way that we are addressing some of these issues here in our particular country. And I will say that there have been some recent reform that has happened. New Jersey in 2017 has done some remarkable work around bail reform. And obviously just last month, we heard about Illinois and a win that they had in particular as it relates to ending cash bail as a part of a larger criminal justice package. But this last slide just basically says that, that since 2000, 90% of the growth in the overall jail population is due to people who have not actually been convicted of a crime. And I know that is a question that I've asked recently just in the city that I'm in here, which is Cincinnati, about what are our numbers of people who are sitting in pretrial versus the people who have actually been convicted within our jail. And so I just want to kind of leave you all with that. And I am going to have to get off early, but if anyone has any questions for me, any additional information, I have a lot more slides than this, but obviously a short window of time. So, if you have any questions, please feel free to reach out to me. I will put my information in the chat.
Thank you so much, Dr. Zaria. I really think the history and the background of how we got where we are in 2021 is so critical to this conversation. So I really appreciate your presentation. I feel like I learned something new and have a different takeaway every time I see you go through it. So now we're going to turn to the state of pretrial justice in Ohio. And I'm wondering if, Claire, you could walk us through what currently happens in relation to bail here today in 2021 in Ohio.
Absolutely, and thank you so much, Jocelyn and Chief Justice O'Connor and Dr. Zaria Davis. So as a disclaimer up front, Ohio does not have a unified court system. So while all state trial level courts in Ohio are obviously bound by the Ohio and United States constitutions and the Ohio Revised Code and the Supreme Court of Ohio criminal rules of practice and procedure, there is still a lot of variability, and that's especially true within the pretrial period. And so while I'm going to describe generally what takes place now, it's important to recognize that there's a lot of variability, and I'm going to try to address that. So what I'm describing might not be what you see in your specific jurisdiction, but exists somewhere in Ohio. So if you and I were both arrested today, let's say for the same thing, because we were doing it together, and we were both arrested for theft, and it was charged with a first-degree misdemeanor. It is likely before either of us ever see a judge that we would have the opportunity to buy our freedom through something called a bond schedule. So a bond schedule is a table that on one side will list either a specific crime like theft or a crime level like first-degree misdemeanor or a combination, and then a corresponding dollar amount that you can pay in order to buy your freedom before ever seeing a judge. And now these bond schedules are one of the things that vary widely across the state of Ohio. So while all municipal courts are required to have a bond schedule for misdemeanors, Some municipal courts also choose to have felonies listed on the bond schedule as well. If you're curious for an example, Google Pike County, which specifies like what you have to pay to get out of jail if you've been charged with murder. And so what's important here is, there's very rarely at the bond schedule level any discussion about, are you culpable? Are you the correct person? Are you able to afford this amount? Now, there are some bond schedules that have, disclaimers that specify that those sorts of things can be taken into consideration. But overwhelmingly, it's just, do you have this dollar amount and can you buy your freedom? And again, those dollar amounts change wildly across different jurisdictions. And also, as a side note, when I say jurisdictions, I'm not just talking about our 88 different counties in Ohio, because our friends in Cuyahoga County know that we actually have some counties with more municipal courts than just one within the same county. And even those municipal courts will do things differently from each other. So what happens next? So let's say we're both arrested and we're faced with this bond schedule in the jurisdiction where we were arrested. If you're able to afford the amount next to your name or next to your charge, you're going to get to post that money and you're going to get to go home and you're going to get to tuck your kids into bed that night and you're going to get to go to work tomorrow and you're going to get to continue to pay your bills. If I'm not able to afford the exact same amount, I'm going to stay in jail until my hearing. And what's important is there's a lot of differences between when that hearing might take place depending on where in Ohio we're arrested. In some places, that hearing might really take place within 48 hours, which is a good best practice. In some places, it won't. In some places in Ohio, there's only misdemeanor arraignments on Tuesdays and Thursdays, for example. So if we had gotten arrested on a Thursday night, I'd be really out of luck until at least Tuesday, and hopefully there would be room for me on the docket on Tuesday. So some places in Ohio, I would be looking at pretty substantial pretrial detention before I even see a judge. Whereas you, because you had money, would be able to be home with your family. So then what happens next? So also something that has a lot of variability in Ohio is what that initial hearing looks like. In some places in Ohio, even before the pandemic, those hearings would be done by video conferencing. So for me in jail, that would look like probably in some sort of jumpsuit, maybe handcuffed, speaking with a judge through a video camera. Or it could look like I'm brought to court. Again, for me, it would probably be in a jumpsuit, and for you, because you were released pre-trial and pre your initial hearing, you'd be able to come in with whatever outfit you chose and be able to walk yourself in. And then also what varies across Ohio is whether we're going to have access to counsel at this important time period. So in some places, I will have been assigned counsel if there was a determination of indigency and that I needed counsel. In some places, I won't have been assigned counsel by that first hearing. In some places, counsel will have been assigned early enough that I'd be able to communicate with my counsel before this initial hearing. In some places, I will have only gotten to speak with my attorney at the moment I met that person in court. And in some places, it would just be assigned later, and I would not have counsel at that initial hearing. Of course, for you, if you were able to afford it, you would potentially be able to choose your own counsel, pay for them, and make sure that they were available at that initial stage, even if it was a county that wouldn't provide counsel for me at that early stage if I was indigent. So then what happens next? And again, Chief Justice O'Connor said up front that there have been a lot of positive changes about the bail setting procedure, including that Criminal Rule 46 now specifically requires judges to set the least restrictive conditions necessary, I think specifically to avoid non-appearance and to ensure safety and to ensure that somebody accused of a crime does not obstruct justice. Now, one of the problems here, though, is that judges aren't required to put those findings on the record. So they're required to only set the least restrictive conditions necessary, but they're not required to demonstrate what's least restrictive and what makes it necessary, or why something is specifically required based on this person's individual case. And so unfortunately, what we see is, there have always been judges across Ohio who make sure bail reform exists in their courtroom because there's nothing requiring judges to set bail, and to work with individuals to make sure that they're not setting a condition of release that's going to lead to unnecessary detention. We also know that there are judges across the state of Ohio who don't, and who very quickly set financial conditions of release. And unfortunately, one of the things that we're seeing is even though Criminal Rule 46 now has this strong language, judges aren't held to actually follow it because they don't have to show their work. And so that's one of the issues that, unfortunately, when you and I have our first appearance for this first-degree misdemeanor theft case, it's possible that we're going to get another financial condition of release set. And it's possible that you once again might be able to pay for that condition. And it's possible that I won't be able to, and then I would remain in jail. And this is a problem for a number of reasons. You know, I said up top, people who remain in jail pre-trial are put at risk of losing their job, their housing, even custody of their children. You know, if you think about it, if you were arrested today for something that you didn't do, would somebody even know to feed your pet if you remained in jail? And also, it makes a mockery of our entire criminal legal system, because it actually, if you are held pre-trial, you're actually more likely to have worse case outcomes. And so what I mean by that is that I would be more likely to be convicted, more likely to be sentenced to jail and prison, and more likely for those jail and prison sentences to be longer. For first-degree misdemeanor theft, it would just be potential jail, not prison sentence. Compared to you, who was charged with the exact same crime, but who was able to buy their release throughout the pretrial period. And that's because it makes sense. For something like first-degree misdemeanor theft, it's possible, you know, I could get probation if I plea, or I could remain in jail for the next couple of weeks, maybe months, to demonstrate my innocence at trial. And for some people, they don't have that privilege of making that choice. You got to get to work the next day, and you got to feed your kids, and you got to be able to pick them up from school. And so it isn't really a choice, stay in jail for the next few weeks to demonstrate innocence, or plead guilty today, maybe for something you didn't do, and actually get to go home to your kids. And so it increased pretrial detention, especially unnecessary pretrial detention, increases the likelihood of conviction through plea deals, but also because it's just harder to build cases from behind bars. You'd have different access to defense attorneys, you'd have different access to evidence gathering, and different access to, you know, maintaining resolve from behind bars. So I'm actually going to pass it now to Anthony Body from the Bail Project, who's going to talk to you a lot more about, you know, how this affects individuals who go through this process.
Hey, how you doing? As Claire had mentioned, you know, it all depends upon each individual. I always like to say it's different strokes for different folks. So before I get into bail, I like to always talk about how where bail starts at the arrest. So you could take Claire and myself, for instance, if we're both walking across the street, say for a jaywalking ticket, and we're stopped by law enforcement, both our interactions with the police that officer may be different. So while she may comply and I may comply just as well, whatever that officer writes on that ticket starts the bail process. So that ticket starts essentially how much your bail could potentially be. So we know how lopsided this justice system is for poor Blacks like myself and so forth. So 9 times out of 10, Claire will get a citation and she'll be able to go on about her day. And myself, I may get assault on a police officer or resisting arrest, and where I may end up in jail and I may have a $5,000 to $10,000 bond, and it can spiral out of control. So if we talk about how the bail system impacts each individual, again, it depends upon who you're asking, depends upon your socioeconomic class, and depends upon your color, the neighborhood you live in, and so forth. But if we look at it on a macro level, overall, we can say that $15 billion annually is spent with holding people in jail, legally innocent people in jail, holding them hostage. So it affects us all. But if we think about how the current bail system currently discriminates against Blacks and poor people, we can say how that impacts them more than anything. So here currently in Cuyahoga County, you know, we have where Blacks are more than likely to have a bond set at over $10,000, and also are more than likely, or 23% less likely to have a personal bond in comparison to whites, where they'll have a 33% chance of receiving a personal bond. So as Claire mentioned earlier, with this whole process of receiving a bond and not having a bond, or having a bond that's within your range, it depends upon the outcome of your case, the time you spend in jail, and also it can actually change the trajectory of your life. So say, for instance, if we have an individual, Cleveland, I'll start with Cleveland now, with Cleveland being the poorest city as it relates to poverty in the country, with 31% poverty. You got most individuals who wouldn't be able to afford a bail. So we have folks squandering away in jail and, you know, being impacted by the carceral effects of the criminal justice system. She mentioned that one day in jail can impact your life tremendously, because you can lose your housing, you can lose custody of your children, your cat, dog, or whatever. So the longer you stay in jail, the larger the impact. So the higher the bond, the worse the impact. And with Blacks, we see that Blacks are more than likely to sit in jail longer than anyone. So the impact of individually, we think of things on a national level. We always use Khalif Browder as an example of someone who was impacted by bail. He had a $3,500 bond and couldn't make bond, and ultimately was released 2 years later, and ultimately ended up committing suicide. But we don't a lot of times draw it back locally, and we have individuals right here in our backyard. Like on July 8th, we had Michael Warmick, who was in the Cuyahoga County Jail, a guy who died because he had a $5,000 bond, and the crimes that he committed were crimes out of survival. He was a homeless man that lived in 2100 Lakeside, the homeless shelter, and he couldn't afford bail, but he was ultimately sentenced to a death sentence because he couldn't afford bail. So the Constitution grants us all the right of due process, liberty, and the presumption of innocence. But a lot of times, 9 times out of 10, it depends on the judge and their discretion. You know, every judge has that thing that they don't like, whether it be domestic violence, guns, and so forth. So that discretion that each of these judges have, it allows them to maybe use some of their biases to set the judge, because it's nothing across the board that just allows everyone to be treated fairly. So with Michael McCormick, homeless Black man in his 50s, he died in Cuyahoga County Jail, all because he couldn't afford bond. That shows just how the system impacts one set of groups more tremendously than the other. So when we think about bail on an individual level, I want to say, like, it all depends upon the individual, like the socioeconomic class and the race class. And that's pretty much it. Because Claire pretty much answered. She was the interlude to my comments. So with the $15 billion annually spent holding in jail, if all of us work together and elect officials and put officials on the bench who are for bail reform and for help creating this just system, we can create a lot of change, and that can impact us in a positive way if we all use our voices to get that accomplished. But as Zaria mentioned earlier, with mass incarceration and pretrial detention for majority of the folks that are currently incarcerated in jail, and majority of folks who are currently incarcerated in jail are Blacks. If we look at the percentage, you say the impact of this bail system has drastically impacted Blacks more than any other individuals within this country. So that's the impact. Individually, it depends upon who you are, what neighborhood you stay in, your relationship, your financial income, or in the color of your skin.
Thank you so much, Anthony. I really appreciate your comments. I think we know racial disparity exists from start to finish, from policing to sentencing in the criminal legal system. And I think that we also see it in the context of bail. And so I just really appreciate your comments and the work that you do with the Bail Project in Northeast Ohio. So I'd like to switch gears a little bit, and I'm wondering if, Daniel, you can talk about case outcomes and public safety under current bail practices in Ohio.
Sure, thank you. So first, I'll just start off by saying that I'm here in my personal capacity. My current employer does not work on this issue. Maybe I can change that in the future, but it's an issue that I'm very passionate about. And I think that an issue that gets overlooked a lot of times is the public safety perspective of cash bail. A lot of times that's what we hear as an argument against bail reform, is that we'll see spikes in violent crime or other property crimes or what have you. But I think it's important to remember that when people are arrested, they've not yet been convicted. So it is illegal. It is unconstitutional. It's a violation of due process to hold somebody for the purpose of punishment. The Supreme Court has said that holding people for public safety reasons or to ensure their appearance, that may be appropriate. But when we over rely on cash bail, it really hurts public safety. The amount of money to which a person has access to post bail makes them no more or less dangerous. Depositing money with a court or a bail bondsman does not make you any more safe. And the purpose of cash bail is to ensure that people return for their court dates. It was never intended to be used as a proxy for public safety. But instead, what we see now is that in many cases, cash bail is being used to hold people indefinitely. You'll often see news articles where somebody is accused of some heinous crime, and you'll see some enormous amount set for cash bail. You'll see $1 million cash bail, $2 million bail. And I always ask myself, does the judge or the prosecutor who asked for that amount really think that if they deposited that amount of money, that they should be released? Ohio law does allow for people who are arrested for certain offenses to be held without bail. So why isn't that used? Well, because it's hard. It takes a little bit of effort. ORC 2937.222 in part says the state has the burden of proving that the proof is evident or the presumption great that the accused committed the offense with which the accused is charged, of proving the accused poses a substantial risk of serious physical harm to any person or to the community, and of proving that no release conditions will reasonably assure the safety of that person and the community. So there is a mechanism, there is a way for it to be done, but it's a lot easier to just ask for a lot of money. And so what we've seen is we have anecdotes. The Chief Justice talked about telling stories. Not only do we have stories of people being held in jail for way too long, or even being in jail at all for offenses that they're accused of committing that they shouldn't be. But we also see it going in the other direction. We see people being let out, people who probably should be detained, not being detained because they're able to make cash bail. And as the last presenter mentioned, depending on your circumstances, you could have very different outcomes. So I'll talk about two young men, roughly the same age, roughly at the same time, one in Dayton, Ohio, one in Pennsylvania, north of Philadelphia. The young man in Dayton, Ohio was arrested for trespassing on public transportation because his clothes didn't meet the requirements of the RTA. The other was arrested for murder of 4 people. The kid from Dayton, the young man from Dayton, his bail was set at $150. He wasn't able to make it. He sat in jail for 8 days until his mother was able to get a car title loan to post his bail. The young man in Pennsylvania came from a wealthy family. The bail was set at $1 million. He posted the bail and was able to get out. He was later rearrested when he was driving one of his victims' cars around, and later pled guilty to murdering 4 people and burying them on his family farm. So we see that there were 2 very different outcomes for people, and it's the opposite of what you would expect. But that's not all. Those things happen. In Stark County, there was a man who was charged with assaulting his wife with his car. He tried to use it as a battering ram. Bond was set at $100,000. He paid his bail. About 2 weeks later, he killed her. Youngstown, Ohio, there was a man charged with raping his girlfriend's 10-year-old daughter. Bail was set at $200,000. He paid his bail. On the morning that his daughter was set to testify, his girlfriend's daughter was set to testify against him, he set fire to her grandparents' house, killing her grandparents and the 10-year-old girl. Cash bail and allowing people to use this process does not make us any safer. So what about individuals? What about the data? Those are anecdotes. What about data? Well, when held 2 to 3 days, low-risk defendants are almost 40% more likely to commit new crimes before trial than equivalent defendants held no more than 24 hours. When held 8 to 14 days, low-risk defendants are 51% more likely to commit Another crime within 2 years after completion of their cases, then equivalent defendants held no more than 24 hours. What about states that have done comprehensive and jurisdictions that have done comprehensive bail reform? New Jersey is held out as a great example of bail reform. Just to show you how effective it's been, in 2014, their pretrial jail population was about 8,900 people. It dropped to about 5,000 in 2018. Crimes by those awaiting trial was almost the same. The appearance rate dropped just by a couple percentage points, so it's roughly the same. Cook County, Illinois, where Chicago is, has done some bail reform. Studies from the Cook County courts themselves and from Loyola universities found that the reforms did not increase crime. I think that the hot debate that everybody's talking about right now is New York. New York had its bail reforms go in January this year, and almost immediately there were complaints from law enforcement and prosecutors and judges about bail reform and saying that it's causing this huge spike in crime, which was incredible because the law had just gone into effect. I think that the data is too early to really tell what effect it's had, quite honestly. But there is some pretty good reporting talking about the ability of law enforcement to manipulate data for crime statistics based on what they say a piece of property is valued at, those kind of things. But the things that they can't change are shootings, murders, and rapes, which the data has showed had not increased, at least at the last study that I had seen. So I think that no matter what aspect you're looking at it, when we rely too heavily on cash bail, it does not make us a safer society. In fact, I would argue that it makes us less safe. And I wrote a report on that to that effect when I was at the Buckeye Institute, and would encourage people to look at that. Thanks.
Thank you so much, Daniel. I really appreciate your comments on how bail reform can actually promote public safety and help make us safer. I want to note that we're running a little bit over, so I was going to have some slides on the fiscal impact of bail reform, as well as talk about the use of risk assessment tools in the pretrial context, which, spoiler alert, the ACLU does not support the use of risk assessment tools. We have several concerns with them, especially as it relates to using them in the pretrial context. So I will do my best to get the information that I was planning to cover to all of our attendees today, probably via email early next week. I'll work with our technology director to get something set up. I do want to note our fiscal impact analysis. We worked with stakeholders in Athens, Franklin, and Cuyahoga counties to do a deep dive review of the cost savings of bail reform. And to be able to do that, we actually had to figure out who was in jail pretrial and why. And it was really illuminating, right? I think, and this relates directly to the public safety argument that Daniel was just talking about for us. We found that 63% of the people who were being held in jail pretrial were there for a misdemeanor or a non-person felony offense. And the most common felony charge was drug possession. And in 3 of the 4 places that we looked, the most common misdemeanor was driving under a suspended license. And I think that just goes to show that we can achieve comprehensive bail reform, and that can promote public safety, because our position is that many of those individuals, that 63%, probably don't need to be in jail pretrial, and probably are there because they can't afford their monetary bond. So I just wanted to make that quick note. And again, we'll be dropping some resources in the chat, and we will figure out the best way to get all of the attendees information early next week after the conclusion of this program. And with that, I would like to pivot to the future. So we're talking about the history, where we are today, some of the arguments in support of bail reform. And I'm wondering if I could toss the mic back to Claire to walk through some opportunities that we have in the current landscape.
Absolutely, thank you. So back up top, I talked about bond schedules and how right now in Ohio, before you ever see a judge, you might have the opportunity to buy your freedom. And as Daniel Dew described, that does not promote public safety. It means that wealthier individuals with money can buy their freedom even if they're potentially dangerous, and those without money end up languishing in jail, like Anthony and I discussed. And so, but also we recognize that a number of people who we've spoken with, stakeholders who work in the criminal legal system, some like bond schedules because it provides judicial efficiency, because at least some people are getting released pre-trial, and their initial hearings can be set further out than those who remain in jail. But the problem is it's a release based on money, not on safety. And so what we envision as a change is that same release valve can exist, but for everybody, not just based on how much money do you have. And so what we want to happen is within the first 24 hours of an arrest, everybody is released, unless the prosecutor or a judge believes that there's a concern for the safety of a specific individual, or there's a concern of willful flight. And then that person could be held in jail, and a hearing would be scheduled for within the first 48 hours to determine what conditions of release are necessary, or for those eligible for preventative detention, which Daniel discussed, that they could have a detention hearing. Basically, that creates the same thing that exists now, except instead of resources determining whether or not you're free, if you actually pose a threat, would determine whether or not you're free. It's also important to note, and I think I've actually heard Chief Justice O'Connor say this before, that bail reform can occur right now in every judge's courtroom. There is nothing in our laws or Constitution, both Ohio or the United States, that requires financial conditions of release to be set. But there are a number of procedural safeguards that exist to try to get judges to consider other options and to consider release, or to consider the least restrictive conditions necessary, or to consider the least costly cash bail amount if a financial condition of release is going to be set. And so what also is important is that if cash bail is going to continue to get set, it should really only be if there's a concern of willful flight. And that goes back to what Daniel was talking about. Cash bail doesn't promote public safety. Wealthy people who might be dangerous get to be free, and people without resources who aren't have to stay in jail. That doesn't make sense. But the only reason, and actually based on a couple of recent Supreme Court cases, the only reason for setting a financial condition of release is to support the reappearance, to get people to want to return back to court. And so unless there's a concern that somebody's actually going to flee, then cash bail shouldn't be set for any other reason, like public safety. It's also important to note that when we talk about willful flight, that's different than appearance. We know that actually people very rarely are trying to flee justice. If there's somebody who has a private jet and a house in a country without an extradition treaty, maybe it makes sense to set cash bail. But most people aren't trying to flee justice. In fact, most people are trying to show up to court, but there might be other barriers in place that might stop them from showing up to court, like they forgot, or they relied on public transportation, or they couldn't get childcare. And so if we want to focus on making sure that the justice system is working as efficiently as it can be, and that would include, working to decrease failures to appear, one of the single most effective things to do is not set cash bail. It's actually to just have court reminders. In the same way that my dentist harasses me leading up to an appointment because they'll lose money if I fail to show up, we can do something like as simple as court reminders, which has been demonstrated to wildly increase appearance rates and can be done for pennies per text. So if anybody has any questions or wants to dive a lot deeper into policy proposals with me, I'm happy to do it, and you should feel free to contact me after this or ask questions now during Q&A. Thanks.
All right, thank you so much, Claire. And I'm hoping everyone virtually, visually can help me thank all of our speakers. You can use the reaction or just hold your hands up and clap. Thank you so much, everybody, for the robust discussion that we've had this lunch hour. We do have some time we've got about 15 minutes left for Q&A. So if you do have a question for one of our speakers, please place it in the chat, and myself and 2 other staff members will do our best to pull those out and get through as many as possible. I do want to note that we had a couple of questions come in advance of today's program. And again, these questions related, unfortunately, to topics that I needed to buzz past in the interest of time, related to risk assessments and the fiscal impact analysis. And so I just want to note that if we don't verbally address a question, that we will provide responses in a follow-up email. But very quickly, I just want to note that a question came in about if bail reform, if one goal is to reduce racial disparity, how do we explain the use of risk assessment tools in New Jersey that showed no change in the racial makeup in jails based on 2017 and 2019 annual reports? And I just wanted to make a note that I think it's really important when we talk about bail reform that yes, we can look to other states and learn from them, and hopefully, learn from mistakes, see what is working well other places. And Ohio is not going to be, the first state to implement comprehensive bail reform, but hopefully it won't be the last. And because of that, we have the luxury to learn and grow from others. But in relation to the racial disparity point with New Jersey, I just wanted to note that we actually don't need to look at data coming out of New Jersey because we have that data right here in our own backyard. And unfortunately, what we see here in Ohio is that there is racial disparity in the use of risk assessment tools. Our fiscal impact analysis, I'm hoping one of my colleagues can drop that in the chat again. That report does include a couple of pages on the use of risk assessment tools in Cleveland and in Franklin County, and it does show racial disparity. In Cleveland, of those whose assessments were considered, 75% still had a money bond set. Even those who were determined to be low risk by the risk assessment tool were still detained or had bail set 60% of the time. And on average, we found that Black people consistently scored higher on the risk scale than white people and were detained more often, as well as had higher bonds set. So unfortunately, if the data in that regard is good coming out of New Jersey, we still are seeing the racial disparity here in Ohio. And if we have the data in our own backyard, I think that we should look to that. So again, thank you everyone for all the questions and all the engagement. We're gonna try to get as many responses as we can. And I'm hoping to actually ask Claire the first question, which again was one that came in advance. And Claire, I'm going to read it verbatim. So this is not me, this is a verbatim question. Assuming defendant appearance at court hearings is important to the judicial system, the use of cash bail is an option that has the highest appearance rate. So why eliminate it?
Thank you for that question and the opportunity to answer it. I think, unfortunately, I disagree with the premise of that question, and so does a lot of the recent research. So as a way of some background, and I think this also answers a question in the chat, there are a number of different kinds of financial conditions of release. There are 10% bonds, there are property bonds, there's, financial bonds like cash bonds. All of those different kinds of financial conditions of release can get categorized in one of two categories, either secured bonds or unsecured bonds. And so secured bonds are usually what we're talking about when we are talking about cash bail. And secured bonds require that you post money up front. So you don't get to leave jail unless you post the money up front. And that's what leads to wealth-based detention, because if you can't afford it, then you remain in jail. Unsecured bonds means that you don't have to put money up front, but if you fail to appear, you're still on the hook. You would then have to pay that money to the court. And that doesn't lead to wealth-based detention because you get to leave without posting anything. And so actually there's a ton of research coming out that there's no difference in the incentive to appear between unsecured bonds and the secured bonds, which actually do increase wealth-based detention. And we also have a number of different, locations that we can use as an example for this. Washington, D.C. got rid of secured bonds or cash bail in the early 1990s, and they have, 94% of people are released pre-trial, and over 90% of people appear for all of their court dates. And that's actually a higher appearance rate than a number of different jurisdictions that do rely on secured bonds. So I can actually quickly post some of that research that I'm referencing into the chat so you can see what I'm referring to with all of the different studies that have looked at secured bonds and unsecured bonds. So I'll just post that now.
Thank you, Claire. I think you did answer a couple of questions that have just come in recently on the chat as well. I'm hoping to pose a question now to Anthony, another question that came in early. Anthony, I'm wondering if you ever see different bail amounts or different outcomes for your clients based on the courtroom that they land in. You're still muted.
Oh, it just allowed me to.
There we go.
Absolutely. Absolutely. As I mentioned earlier, it's really dependent upon the judge. The main word that relates to bail and or the word I hate, bail and policing, is discernment. I mean, discretion. These judges have too much discretion. Some of these judges, like, they have that thing that they hate. So you can get someone who goes into a judge courtroom who maybe she's having a great day, and I'm not gonna say any judge's name. She's having a great day, and everyone will receive personal bonds across the board. Then you can get a judge where she's been on the news, and she can have a bad day. The individual before her could have, for lack of better words, pissed her off, and the next person that came after, someone received a $50,000 driving under suspension bond, and that's just absurd. So with the discretion that these judges have, it allows them to really, just do whatever they want to do. So it leaves an unbalanced playing field. And to the question that Claire answered earlier, cash bail, like even though whether it's secured or unsecured, it gives people a different sense of safety when, say, within those wealth groups. So if you get an unsecured bond and you don't have to pay that bond up front, you have the ability to miss court, or if you choose to, because you can afford bail. Whereas individuals with different variables in life can be a hindrance to you making it to court, whether it be childcare, a job, bus breakdown, you can't ride your bike, and so forth. You don't have that luxury. So, and then putting money up front, it puts a burden on people. As I said, with Cleveland, using Cleveland as an example, with 31% poverty, you get individuals who are forced to put up money for their freedom. And I don't know who wouldn't put money up for their freedom to get out of jail, money that they don't have. So now it increases the likelihood of them maybe missing a bill or not being able to put food on the table and so forth. So now they have to make other decisions to commit an alleged crime for survival. So cash bail isn't the way, because it's fair. It's not fair across the board where, folks who can afford it, they can pay and not think about it, while individuals who can't pay are forced to do whatever they have to do to survive.
Thank you so much, Anthony. I'm wondering, Chief Justice O'Connor, a question came in for you in the chat. Our audience would like you to elaborate on your opening remarks on why we need to stretch further than Criminal Rule 46. And I'm just wondering if you can talk a little bit from your 30,000-foot vantage point, what you've seen in Ohio.
Well, I'd be the first to admit that I am dissatisfied with our rules of court when it comes to bail and when it comes to, a variety of things that we do, not just in this arena. But I think it's important to understand what the process is and how these rules are created. And we'll start there and then move on. We have 7 justices. And when we have in our administrative meetings, and then we have, amendments to our rules that come before us at our conferences. And it takes 4 justices to approve a change in the rules. And if we don't get 4 justices, if we only have 3 justices to change the rules, whether the rules of criminal procedure, civil procedure, any of the rules, appellate, etc., rules of superintendents, they don't get changed. So it's not a system where I, as Chief Justice, can dictate what the changes will be. If that was the case, we'd have a very different system that we have. But there's 7 independently elected justices on the Supreme Court, and each one has a vote. You vote for those justices, by the way. If you're interested in, this topic, you should be interested in finding out how the justices vote on areas such as, bail reform, and a host of other issues that you may very well be interested in. It makes a difference. So oftentimes, well, I think what we get passed, as I said, is not the ideal. I'm someone who, I believe in compromise on certain things. There are other things that I think should not be compromised. But Rule 46 was the best, that was the best version of the recommendations based on the vote of the justices. And that's how it works. So, to say that it's less than perfect doesn't go as far as I would like to see it go. Well, apparently it went as far as 4 of my colleagues wanted to see it go.
I really appreciate that background. I think it really is helpful to know how we got what came out through Criminal Rule 46. And I know a lot of folks who are attending the call today did submit comments during the public comment period, and it was the result of some compromise and a vote. So I really appreciate that transparency. In the interest of time, I'm going to pose one final question to Daniel Dew. This question just came in through the chat, and the question is essentially, is cash bond only to be set when it will help assure the defendant appear in court? If so, instead of a 5 million bail, a judge should order a no bond and demonstrate why on the record. And this kind of goes back to, when should we be using cash bail? What's the law there? What is no bond? Can you give us a quick recap of that, Daniel?
Yeah. So I think the premise of the question is correct. It should only be used to ensure that a defendant appears in court. I like to think of it, it should be like a preliminary injunction on this, on the civil side. The prosecutor should present a high likelihood of success on the merits and the high probability of irreparable harm if the action isn't taken. And that should be the standard that we should have with somebody, whether somebody should be held pre-trial. Otherwise, I do think that cash bond may make sense in some circumstances, just when you're trying to make sure that they appear. But it shouldn't be buy your way out, and we're going to use this as a substitute for public safety.
Thank you so much. That was very clear and concise. I appreciate that. And we are 60 seconds out, and everybody had my word that I would keep us on track today. So again, I just want to thank all of our fabulous presenters today and thank our audience. And I hope you all are heading into a wonderful, restful weekend. Thank you so much.